بسم الله الرحمن الرحيم. ومن مسائل الأحكام في التبع يثبت لا إذا استقل فوقع.
Naam. So this is the next principle, inshallah ta'ala. The author, rahimahullah ta'ala, he didn't really mention the mother principle here. And to be honest, the mother principle would complicate things a lot. But this sort of sub-principle of that mother principle is one of the most beneficial principles in Islam, as we'll see, inshallah ta'ala. The mother principle is referred to as at-tabi'u tabi'un. At-tabi'u tabi'un. So it's a principle of dependency. When one thing depends on another. So at-tabi', which is the following, the one that follows and depends on something else, is always in a state of at-tabi'iyyah. It follows that thing. And this is a principle, as we'll see, it applies to all sections of fiqh, all of the chapters of fiqh, inshallah ta'ala. This sub-principle that he mentioned here, وَمِن مَسَائِلِ الْأَحْكَامِ فِي التَّبَعِ, that from the issues of ahkam that relate to this general principle known as at-tabi'u tabi'un, is the sub-principle here that he mentions here, يَثْبُتُ لَا إِذَا اسْتَقَلَّ فَوَقَعَ. يَثْبُتُ, that you affirm it, that it becomes valid, لَا إِذَا اسْتَقَلَّ فَوَقَعَ, meaning that it's valid as long as it remains in that realm of dependency. لَا إِذَا اسْتَقَلَّ فَوَقَعَ, meaning not if it's alone and separate and independent. What does this all mean? What it means is that, in a nutshell, that which cannot be established independently cannot be established dependently. If something cannot, you can't sell it, or you can't sell it separately. For example, we'll see examples of it anyway, that some things are basically invalid if you take it independently. Some things are invalid. Their ruling is not attached to them if they are invalid. Again, we're going to see this, inshallah ta'ala, as it relates to this principle. This principle, in reality, is to close loopholes. Al-Fiqhiyyah. So where some people want to open up loopholes, this principle closes it, whilst it still leaves room for flexibility in some scenarios. I'm going to go through a number of ayat, inshallah ta'ala, in a hadith, to prove the general principle first, which was at-tabi'u tabi'un, the general principle of that things depend, if they're dependent on something else, then they remain in that realm of dependency and they're valid in that realm of dependency. Allah tabaraka wa ta'ala says, for example, وَلِكُلٍّ جَعَلْنَا مَوَالِيَ مِمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ. وَلِكُلٍّ جَعَلْنَا, that to each individual we've assigned mawali, heirs that they inherit from their walidan, from their parents, wal aqrabun, and their close relatives. This means that you as an individual, your progeny will inherit from you as long as they are there. Nobody else gets to inherit from you, or from you, for example, you from inheriting from your parents or your relatives, whilst you are there. This is a concept known as hajm. So what it means is that the general principle is that as long as those dependents are there, then they take exclusivity in that premise. The opposite is true as well, where things are invalidated because they are not dependent. The hadith of the Prophet ﷺ comes to mind. نهى النبي صلى الله عليه وسلم عن بيع المولود في بطن أمه. The Prophet صلى الله عليه وسلم said, and he prohibited selling an animal that is in the stomach of its mother. What does this mean? Say you have a camel, yeah? You want to sell that camel. That camel is also pregnant. Together, can I sell it and up the price? Say the camel costs 1,000 dinars, the baby camel costs 200. I'm going to sell it to you for 1,200. Is that fine? That's all right. What is it that the Prophet ﷺ saying you can't do? That's allowed, that's jaiz.
The baby can
Selling the baby on its own. I can't come to you and say there's a baby in the stomach of that thing and then I'm going to sell it to you. Does it make clear? Why can you not sell it on its own? Because it's not separate. It's not distinct. It's a part of its mother. Does that make sense? So you cannot sell it individually, but you can sell it with the mother. Does that make sense? This is what the principle of dependency means. This has varied examples. Can somebody worship Allah Tabarak wa Ta'ala by doing ruku' without salah? But you can't do ruku' within salah, right? Why can you do so?
It's part of salah.
Because that ruku' is dependent on the prayer. The prayer,
It's inside the.
it's inside the prayer. You can't do it independently, but you can do it as a part of something, as a bundle. Does that make sense? This principle is hugely beneficial. It applies to salah. It applies to other areas. We spoke about the concept of bay' al-haml fil batn. That's a very famous scenario where the fuqaha, for example, Ibn Qudama rahimahullah ta'ala says, so it's known as, the first mas'ala is known as selling an unborn animal. It's prohibited. What is prohibited? Selling it individually and separately, isolated. That's not what's allowed. As for if you're going to sell it dependently on its mother, sell both together, you can up the price and sell it. That's fine. So here, the Prophet ﷺ prohibited that, and the fuqaha they say, إِذَا بَاعَ النَّاقَ وَمَا فِي بَطْنِهَا جَازٍ وَلَمْ يَجُزْ بَيْعَ الْحَمْلِ مُسْتَقِلًا. If you're going to sell both, that's fine. The second you want to sell it independently, it's not allowed. What's the ruling of? Huh? Here again, there could be multiple reasons why. But the point here is that this principle governs this as well. Does that make sense? There's sometimes with fiqh you'll notice there's multiple principles that apply. Yes, Qawāʿid al-gharar is a huge one. And I wouldn't really say gharar in this particular scenario, but yani, for example, the fact that you don't know if the baby is going to be live or not. You know, you're buying something where you don't actually know the reality of it. But the Prophet allowed selling them together. But you can't do it on its own. The next one is selling unripe crops. بيع الزرع قبل نضجه. Is it allowed? The Prophet ﷺ prohibited what? بيع الزرع or بيع الثمر قبل بدو صلاحه, right? He prohibited, if somebody has like a vineyard of dates, massive farm of dates, those dates have yet to ripen. I come and say I want to buy all these dates before it ripens. It's not allowed. Anything could happen. It might not, reach the stage where you can actually consume it, right? It doesn't reach a point of it being edible, where you're actually able to benefit from it, eat it, sell it, and so on. So you're not allowed to sell. You're not allowed to do so individually. What if I come and I say I want to buy this land, and then those trees, those crops, I buy it with it? Is that allowed? What's the difference here? You can't sell it separately, you can't sell it isolated, but you can sell it with the land. Does that make sense? يَثْبُتُ تَبَعًا مَا لَا يَثْبُتُ اسْتِقْلَالًا. That this thing is valid as it's in that realm of dependency. It's dependent on the land. If you were to separate it, it's no longer valid. Can you see the principle? Another example, inshallah ta'ala, and most of these examples will be from Kitab al-Bay'. The next one is, for example, the tree. Now,
buying the dates when it is
before it ripens. قبل بدو صلاحه. The hadith was in Sahih Bukhari, نهى النبي صلى الله عليه وسلم عن بيع الثمر حتى يبدو صلاحه. Until it ripens and it's edible, you're not supposed to buy it. What happens with the tree, for example? Can I sell individual trees of a land? Forget about the land, for example. If I was to buy and say, you've got all these trees, I want to buy a couple of trees. Not the entirety of the land, but can I buy the tree? You can buy the tree as well. And Imam Malik rahimahullah ta'ala would say, إِذَا بَاعَ النَّخْلَ وَعَلَيْهَا ثَمَرٌ غَيْرُ نَاضِجٍ فَإِنَّهُ يَكُونُ تَابِعًا لِلشَّجَرَةِ. Look how early this principle is. So Imam Malik is saying this is allowed. Why? Because these sort of these dates or these crops on this tree, they follow and they are dependent on the tree. You can sell the tree. You can also make more money from selling these crops that have yet to ripen and are edible, but as long as they are together and not separate. Does that make sense? So the qa'idah here is يَثْبُتُ لَا إِذَا اسْتَقَلَّ فَوَقَعَ يَثْبُتُ تَبَعًا مَا لَا يَثْبُتُ اسْتِقْلَالًا. So again, if you want to jot it down, that which cannot be established independently can be established as a dependent. And you're allowed to sell it, for example, it becomes valid independently or dependently. A good example that sometimes, it's very interesting here is, let's go to marital law. أحوال الشخصية, nikah. If a woman says right now, for example, before you get married, I'm deeply in love with this brother. I don't want a mahar for him. I just want him to marry me. Is that allowed? Can she waive her rights for a dowry, a mahar? I don't want anything. I just want his love. She's allowed to do that. No, she's not allowed to do that. Why is she not allowed to do that? She cannot waive her right to a mahar.
By saying I do not want.
Yes, so before they get married, can she say, I do not want a mahar? Huh?
Waiving of the.
Yes, waiving her right to a dowry, saying, I don't want anything from this guy. I just want him to marry me.
Just right of dowry, not the other rights.
No, just the right of dowry. She wants to drop the dowry. Is she allowed to do that? No, before the marriage. Before they get married, she says, no mahar.
Before the aqd.
Before the act.
No.
She's not allowed to do that. But why? This is agreed upon, by the way. So before the marriage, she's not allowed to do that. Why not?
It's a condition. One of the conditions.
So it's a condition. But why is she not allowed to waive it?
It's the right of the woman. The woman's father.
So here,
Giving her there.
so because you said it's a condition, you need to view it as it being a tabi' to the aqd. Okay? So you say right now that this mahar, right now, is a part of the aqd. Okay? The aqd has to be done, the mahar has to be there. That's how the fuqaha viewed it. So just as you need to establish the contract right now, you need to establish everything that that contract needs. Okay? يَثْبُتُ تَبَعًا مَا لَا يَثْبُتُ اسْتِقْلَالًا. So you have to affirm it for that marital contract to be complete, okay? Because it's a condition. Now after marriage, she says, I don't want to do it anymore. I don't want a mahar. Is that her right? It's her right. Why?
The contract is done.
The contract is done, so it's no longer what? It's no longer dependent. It's no longer taba'. Khalas, it's separate now. The contract is done. Now all she needed was the fulfillment to actually get her mahar, right? No, now it's not dependent. Now it's a separate thing. The contract occurred. She can now say, I don't want anything. She can waive her right to a mahar because it's no longer attached to the marital contract. The first scenario where she was not allowed, it was because it was attached to the marital contract. Now it's no longer attached. Okay? Ibn Qudama rahimahullah ta'ala says, لا يحل للمرأة أن تتنازل عن مهرها قبل العقد ولكن إذا عقد النكاح فلها أن تتنازل. And then he goes on to prove it through يثبت تبعا ما لا يثبت استقلالا. So remember, there's a before and after. Why was it not allowed before? Because it was attached and part of the marital contract. It was allowed afterwards because it was independent afterwards. You could do whatever you want with it. Let's look at another scenario, inshallah ta'ala. We discussed al-irth, right? Al-irth al-taba'i. So to look back at the ayah that we started this with was وَلِكُلٍّ جَعَلْنَا مَوَالِيَ مِمَّا تَرَكَ الْوَالِدَانِ وَالْأَقْرَبُونَ. So every individual has an inheritor, right? Now, what you get in a lot of times is what you refer to as al-irth al-taba'i. What is al-irth al-taba'i? It is when, for example, the son has a father and a grandfather. So who is removed in this process?
Who is removed?
Hajb and irth.
Grandfather.
The grandfather is removed. The grandfather doesn't inherit. Why not?
Father.
Because of the son. Okay? So why was the son here the inheritor, not the grandfather?
Dependency.
Dependency. So they say الجد لا يرث مع وجود الولد ولكن يرث إذا فقد الولد لأنه تبع. Right? Okay? So تبع. So again, the dependency of the child leads especially if the child's young, for example, you can see the maslahah. The grandfather wouldn't need that money. He raised the father. But a child, you can see how the rahmah of the Sharia, this child needs that money. And so the grandfather was removed from the equation because that child was dependent on the father and he needs that sustenance to survive. Does that make sense? So here again, that's an example from thing. We have what is known as al-Wasiyyah al-Mawqūfa. Has anybody heard of that before?
Al-Wasiyyah.
Al-Mawqūfa. Conditional wills. A father passes away. And in his will, he donates more than a third to charity. What happens there?
It's not allowed.
It's not allowed. But what do you do with that will?
Can ask the
Bring it down to third.
inheritor.
That is the opinion of the Jumhur. So you go back to the family. Because you have to understand, a third here, obviously, is the cap, is the limit. But sometimes, some people have a lot of money. And the 2/3 that remain is a lot. So what you do is you do waqf of it. So you stop it and you say, we're not going to give this money to charity. You go back to the family and you say to these children, do you allow this or not? Okay? If they allow it, then it goes through. Why is that the case? Why do we apply the principle of a taba', a dependency here?
They have the rights.
Ahsant. Because that wealth, can you see, mazad al-thuluth, was no longer the right of the father to give. So you don't say, that's it, you don't donate it anymore. You say, this is now the wealth of such and such. So they have the right to donate it now. So this wealth is attached to them. If they choose to donate it on behalf of their father, that's allowed for them. Does that make sense? So that is another example of taba'iyyah in al-Wasiyyah. And so the fuqaha, they say, for example, the hidayah of al-Mirghinani, al-Hanafi, he says, إن أوصى بأكثر من الثلث فهو موقوف على إجازة الورثة للتبعية. But if the individual donates more than a third to charity, then you basically stop it. And it is dependent, it's conditional on the approval of the inheritors. If they choose to allow it, then that's fine. If they don't, then the money goes back to them. Why? Because that money is now their right. Okay? But they can choose to donate to their father.
What the person who is writing the interview, won't the person who is writing the will get the same because he's writing a will which is not allowed to?
No, but sometimes wills are written and nobody else knows about it. It's just hidden and it's taken out after his death.
No, but he wrote it while he was alive, so
Yeah.
won't he get sin for it?
No, he's not allowed to. So sin is different. But the sin is a separate discussion. Like maybe he was ignorant, maybe he didn't know. A lot of things might go into it. We're not talking about sin. We're talking about whose wealth this is now and who has the right to give or not to give. So here in this scenario, that money shifted after his death to his waratha, to his inheritors. They still have the right to donate, which is why we don't say we don't fulfill that. We simply say we put a condition on it. If his family approve of it, we donate. If not, then it stops. And this is all based upon at-taba'iyyah. Because the extra, the portion is valid as a dependent, because it's now dependent on the approval of the inheritors. Yeah.
If somebody makes a will and says the person has a son and a daughter, he says the wealth is supposed to be split half.
That doesn't enter into discussion, aslan, because the thing is, wasiyah differs to irth. Irth are those people that Allah Azza wa Jal puts a fraction to their name. The Prophet ﷺ said in hadith, La wasiyata li warith. So in Islam, you've got two portions, you've got two aspects of looking at this. You've got people that have a designated amount, like for example, sons and daughters. And you have people that do not have a designated amount. Who can you give a will to? No designated amount. So right now, the father has no control in the first half. You know, for example, the 2/3 that he's allowed to do whatever, the 2/3 that he's 1/3 that he can donate to whoever he wants. The 2/3 he has no control over. That goes back to Allah. Allah Azza wa Jal determined that, you know, the daughter gets that much and the son gets that much and so on. Does that make sense? So that wouldn't that you consider automatically that is wasiyya ghayr nafida. You don't look at it to begin with. It's not approval or anything like that. It's just wrong. That cannot even be fixed because he's delving into matters that are beyond his scope. That's the right of Allah. The portion that relates to us is the will, where the individual has the scope of doing whatever he wants with it. Do you want to take one more example of this, or are we clear?
Clear.
Clear? Khalas, we'll move on to the next principle, inshallah ta'ala. I actually like this last one, so I might as well just take it.
Give the example. What is it?
This last one comes in Kitab al-Jinayat. Dhaman as well. We're going to go through Dhaman shortly anyway. Yadman. But it's referred to, the masala is referred to as al-itlaf al-taba'i. Itlaf al-taba'i. Say you own animals, right? Say camels or sheep, whatever it is. They go into somebody else's property and they destroy his crops. It happens all the time. They eat it and stuff like that. What do you do?
Who, the camel destroyed it?
Yeah. The animals, your animals destroy somebody else's property.
Hold the animals.
You are responsible.
You're responsible. Why are you responsible?
It's your animal.
Huh?
It's your animal.
Those animals were attached to you. They were dependent on you. You should have had more control over. That's all that itlaf al-tabi'i is. So the fuqaha, they say that if a person's livestock destroys another crops, he's responsible for compensation even though he didn't intend harm. So they say in atlafat بهيمة الرجل زرعا لغيره وجب الضمان لأنه إتلاف تبعي. إتلاف تبعي. You didn't actually go and harm somebody else's property, but when your property or your livestock caused this harm, so the compensation falls on you. Not on the sheep, of course. Okay? Here, this principle we learn a number of very important things in regards to the Sharia. That some things are valid when they are taken alone. They're accepted. And some things are not. And this applies, like I said, to all chapters of fiqh. Ruku' on its own is not an ibadah. Your sheep, la yadman. All of these are interconnected, can you see? And so the fuqaha, they connected it all with a string and they called it yathbutu tab'an, ma la yathbutu istiqlalan. And so this thing becomes valid when attached to something else. Like I said, this applies to all chapters of fiqh, and it's a way of preventing harm whilst also maintaining that flexibility in the Sharia of Allah Tabarak wa Ta'ala.
Is also a sub-principle of tabi'.
Yes, يثبت تبعا is a sub-principle. So he says here, وَمِن مَسَائِلِ الْأَحْكَامِ فِي التَّبَعِ وَمِن مَسَائِلِ الْأَحْكَامِ فِي التَّبَعِ which can be translated as that among the ahkam, meaning the Islamic rulings that relate to at-taba'. So here he hints at the mother principle. What was the mother principle? At-tabi'u tabi'un. So the mother principle is something else entirely, which talks about all forms of dependency, or talks about dependency from the aspects of validity, invalidity, exclusivity, inclusivity. It talks about a range of stuff, okay? But here, he only took one sub-principle, which is what? يَثْبُتُ تَبَعًا مَا لَا يَثْبُتُ اسْتِقْلَالًا, which is that you can affirm something as being valid, okay? As long as it's attached to something which it was dependent on. So it's not allowed individually and independently, but it would become allowed as attached to something. It becomes valid attached to something. We've seen examples of that, okay? But like, for example, the last masala we took, itlaf al-taba'i. An animal came into your farm and destroyed your crops, but we don't know who this animal belongs to. Who are you going to go get the man from? Who is going to compensate you for your harm?
You have to go to the person for sure.
No, but they say that the animal is not owned. They're animals, right? That is just like, they're not owned by anybody.
Not your animal.
Huh?
Not your animal.
No, nobody's animal. Nobody's animal, just an animal that lives in certain areas.
You cannot do anything.
You can't do anything. So here it would be that dhaman tasqut bil kulliyah. There is no compensation in that circumstance. Here the author Ibn Qudamah is basically trying to say that the concept of dhaman only exists if there is an owner to the animal. If there's somebody you can go back to that you can get compensation from. As for if there's nobody, then there is no compensation because you can't demand animals to compensate.
Right.
Does that make sense?
In this case, the animals are free, and now you have bodies taking care of animals.
Do you have?
The animals which are just free,
Yeah.
cows,
Yeah.
You have organizations and governments.
Obviously, if they have ownership of it, then that's fine. But sometimes what you see with some of these organizations is that they just simply look after the animal that has no home, for example. What they consider, animal rights and things like that. But animal rights does not mean ownership. Just because you want to look after an animal and feed it and protect it doesn't mean you're in control of it. There are a lot of animals that are very difficult to control and maintain and things like that. They're just making sure no harm falls on the animal. But if you generally have ownership of it, and sometimes ownership also dictates that you benefit from this animal in some capacity, right? That's why you would own it. That's why you'd keep it. Today we don't kind of loosely sort of, people just want to have animals for the sake of, just having a friendly home and a cat here and a dog there and whatever else. But back in the days, they served the purpose. A dog was used for security purposes and other such things, maintaining flock of sheep and things like that. You're benefiting, there's a manfa'a to it. There's a benefit to it. Now there, you can turn around and, if somebody can turn to you, if you had ownership like that, and can say, look, that animal is yours, you benefit from it. I want compensation for the harm that it did to me. That makes sense. But here in the scenario where, you're just simply maybe feeding an animal, it doesn't really make sense as much. And Allah knows best. Exactly. We'll move on to the next one, inshallah ta'ala, which is one of the Qawāʿid al-Kuwiyah al-Kubra. What line are we on?
27.
28. The Qawāʿid al-Kuwiyah al-Kubra. So identify this as one of the major principles and maxims of fiqh. We're going to spend a bit of time with this one, inshallah ta'ala. So be aware of it.
أحسن الله إليكم ثم قال رحمه الله والعرف معمول به إذا ورد حكم من الشرع الشريف لم يحد.
So this qaida is the qaida we mentioned yesterday, al-'adatu muhakkama. Al-'adatu muhakkama, which is that customs is a source of legal rulings in Islam. Customs and the norms of society are a source of legal rulings in Islam. The author rahimahullah ta'ala says, وَالْعُرْفُ مَعْمُولٌ بِهِ, that customs are acted upon. مَعْمُولٌ بِهِ يُعْمَلُ بِهِ, that you will act upon it, meaning in stipulating rulings. He says, إِذَا وَرَدْ, if it appears and if it comes, حُكْمٌ مِنَ الشَّرْعِ الشَّرِيفِ لَمْ يُحَدْ, a ruling in our sharia that has no set clear limit. I want to go through this qaida in stages, but I want to quickly explain one thing, inshallah ta'ala, with regards to this terminology of this principle of urf. Urf is a source of ahkam, a source of rulings, right? But here he mentioned a very beautiful point, which is actually sometimes used even as a sub-principle, which we won't go into much, inshallah. We're just going to talk about Adam Hakam generically. But it is that the Sharia defines things, right? Sometimes it defines things by way of giving a set number, right? وَأَقِيمُوا الصَّلَاةَ, Allah Azza wa Jal obligated salah upon us. But then the Prophet ﷺ told us, خَمْسُ صَلَوَاتٍ مَكْتُوبَاتٍ, that the obligatory prayers are 5. This is a direct, explicit number from the Sharia. So the Prophet ﷺ told us that the obligation of 5. Right? Sometimes it's the Arabic language that defines certain things. Right? It gives a explanation for what so that way the Arabs use a terminology. This is how the Arabs use this terminology is also an example. So you have stages to this. So what he means here when he said حُكْمٌ مِنَ الشَّرْعِ الشَّرِيفِ لَمْ يُحَدْ, he's saying that the Sharia did not set a clear limit. That's number 1. Number 2, the Arabic language did not set a clear limit. That's number 2. When these two are absent and non-existent, we don't know what a clear definition of this is, right? We get to this scenario where the urf takes over. So when do you apply the urf? The question is, when do you apply the urf? When do we apply the concept of urf as a source of legal rulings?
When it is, it happens, prevalent.
When it is undefined. The exact amount, the exact nature of what is required from us is undefined. right? So he said, لم يحد. This is very important. ما في تحديد. There is no definite number that was set in the Sharia or in the Arabic language for this thing. Are we clear? As for anything else that has a set definition, then we cannot apply this principle to. And that discussion, which is about التحديد في الشارع, the التحديد في اللغة العربية, we're going to leave it, inshallah ta'ala, just to avoid complexity. But just remember that. Anytime you come across the Quran and the Sunnah about something that is explained and a set definition was given by the speech in the speech of Allah and the Sunnah of the Prophet ﷺ, or the Arabic language defined what is meant by it, urf no longer applies. So urf applies when it's undefined. This is one of the most beautiful things about the Sharia of Allah. The Sharia of Allah, we find two types of law. You have a type of law that is known as ahkamun thabita. From the day that Allah Azza wa Jal first revealed unto us this legislation up until, this whole world will come to an end, that will stay the same. There will never come a day where there will be more salawat obligatory upon us than 5. 5 will always be the number, right? Because this is thabit. And then the Sharia also has what is known as ahkamun marina. Ahkamun marina. Marina, yeah. And what is meant by ahkamun marina is like the flexible ahkam that suit different times and places and so on. I'm going to give you a question. Right? Today, if you were to get married, the nature of like what you can give as mahar, how much you need to live on, these things, would it be the same as 1,400 years ago when the Prophet ﷺ was getting married and his companions getting married? Why do they differ? Because society changed, life changed, the world changed, right? And so the Sharia, تواكب هذا التغيير. It moves along with these changes. That's why al-'adatu muhakkama is such a fundamental principle, because it is the principle that allows this flexibility for the Sharia in all times and places. And so the Sharia, it suits different environments and it suits different places. The fundamental principle is still the same, but how it's applied will vary to suit individual societies, times and places and people and so on.
So, mahar can go back to urf.
We're going to get to that. We're going to give the examples, inshallah, but mahar is a good one. It goes back to urf, yeah. But the point I'm trying to say is that the Sharia is what? It consists of fixed laws, ahkam thabita, and it consists of flexible laws as well that will change depending on the customs and societal norms, and obviously, as we've seen as well, like the structure of how we even get them, these societal norms and customs, it does not oppose Islam, and it was never supposed to oppose the Quran and the Sunnah. If your customs lead to you opposing, the hadith and ayat of the Quran, that's a problem. You haven't applied this principle correctly. Does that make sense? But the way this principle is supposed to be applied is in this manner where there's a structure. The Quran and Sunnah is first, the Arabic language is second, and then comes al-urf. I want to quickly go through the evidences of this principle, and the ayat of the Quran are many. But the key word I want you to jot down is any ayah that contains ma'ruf. Ma'ruf. So Allah Tabaraka wa Ta'ala says, for example, وَلَهُنَّ مِثْلُ الَّذِي عَلَيْهِنَّ بِالْمَعْرُوفِ. And this is regarding an-nafaqah, as we'll see inshallah ta'ala. So from the spousal rights, from the huquq al-zawja ala zawjiha is an-nafaqah, which is the financial obligation upon the husband or her husband. Now, this financial obligation, which is part of this marital obligation, is customary. And that's what the ayah says. وَلَهُنَّ, that they and for them, that the women have and they have a right to, مِثْلُ الَّذِي عَلَيْهِنَّ, that which is rightfully due to them, bil ma'ruf, according to what? The customs, right? Ma huwa al-urf as-sa'id indahum, that which the customs of their society and their time allow for. And so this is, the Sharia is telling us that this concept of a-nafaqah is determined by what? The societal norms. Today, you have to pay for all sorts of bills that didn't exist in the time of the Prophet ﷺ. You don't say the sunnah is, only to care about the food and we can live in a hut. And nobody does that. You have to, give her a house and that is suitable to the time and place you live in. You know, you don't live in a tent, you don't do this, you have to physically go and rent an apartment and the rest of it. Does that make sense? So this is all applying what? Applying the urf. Applying urf. Allah Tabarak wa Ta'ala says, وَالْوَالِدَاتُ يرضعن أولادهن حولين كاملين لمن أراد أن يتم الرضاعة وعلى المولود له رزقهن وكسوتهن بالمعروف. The point of evidence is here is وعلى المولود له. Who is مولود له?
Children.
The father, the one that the child is born to. The one that the child is born to in this ayah, al-mawludi lahu, is al-ab, is the father of the child. So Allah Ta'ala says, وَعَلَى الْمَوْلُودِ لَهُ. The upon the father, meaning the upon that the child was born to the father, that he is responsible for what? رِزْقُهُنَّ. Their provision, their food and so on. So the food and the sustenance of what this child is going to eat is not upon the mother, it's upon who? The father to provide. And then Allah Ta'ala says, وَكِسْوَتُهُنَّ. What is kiswa? Their clothing. He puts clothing on them. Your children. Your children have a right over you as a father to them, that you provide for them, you bring sustenance, something that they can eat, and clothes that they can wear. And this is the right of the children over you. Now, how much do you have to do of it? Do you have to buy a piece of clothing every single day?
No.
Do you have to buy a knife for them every day? What do you do? Huh? The basics. No, the Allah Azza wa Jalla says bil ma'ruf. Customs. What the norm of society is. So it might be that, I don't know, how many times do people eat takeaway in Kuwait?
Takeaway?
Yeah.
Takeaway. When you do.
When you go out to eat, how often do they go out for takeaway? Huh?
Depends upon the status.
Some people eat every day.
So yeah, we have levels here.
Allah understand. So it goes back to that. Whatever the norm is in your proximity.
Middle class, if you are
Yeah, exactly. Yeah, sometimes yes, there's classes and divides in society as well. What the norm is? It might be that the norm is, for example, that you cook them food every single day, and then they eat out once a week, for example. If that's the case, then that's a customary law. This is what you give them. It might be you never eat out; they always eat at home. You provide them what they're going to eat with at home, right? But this all goes back to what? Al-ma'ruf. What the customary law is, according to the customs. And so remember here, bil ma'ruf, it's got a number of meanings, but from the essential meanings is bil ma'ruf. To understand this more quickly, I'm going to quote Imam al-Qurtubi rahimahullah ta'ala. He says, rahimahullah ta'ala, in his tafsir, he says, al-ma'ruf fi al-nafaqati wal-kiswati yakhtalifu bi-ikhtilafi al-zamani wal-makani wa hal al-nas. That al-ma'ruf, which is the custom of what? Al-nafaqa, which is financial maintenance. And al-kiswa, which is the clothing. It varies based upon time and place, and hal al-nas, meaning the financial status of the people. Because sometimes there's a class divide. Some people have more money than others. There's going to be a different sort of approach to things than to other people. The Prophet ﷺ also taught us about the importance of al-urf. And the Prophet ﷺ said in that famous hadith of Hind ibn Utbah, who was she married to? Radiyallahu ta'ala anha. Huh? I heard somebody say it. Sufyan, yeah, Abu Sufyan. She was married to Abu Sufyan, and this was after Fath Mecca, when they both became Muslim. And then she came to the Prophet ﷺ, and she was hiding her face, and because of all those years of what had happened. And she said to the Prophet ﷺ, at the end of the reminder that the Prophet ﷺ gave the women, she said to the Prophet ﷺ that Abu Sufyan is rajulun shahih. My husband is stingy. What do I do? Sometimes, I get my money, I get my financial needs by, dipping into his pocket and taking. So the Prophet ﷺ, what did he say? خُذِي مَا يَكْفِيكِ وَوَلَدَكِ بِالْمَعْرُوفِ. Take what suffices you and suffices your children based on what? Al-ma'ruf. Custom. What the norm is, the norm of society. What suffices you and what the norms of society is. The Prophet ﷺ didn't say, you're only allowed this much dinar or dirham, because that's going to change. That's going to change. And so look here again at the flexibility of the Sharia. Today, we still apply this hadith because we look towards what is a customary night. So tomorrow when somebody comes up to you and says, he doesn't pay me enough, the question you would ask him is, or her, is that, how much does your husband give you, right? And if it's something that is suitable to live on, depending on the society that you live in, you'd say al-urfu or al-'adatu muhakkama, this is suitable. And if it's not suitable, you say, look, you need to give her more because al-'adatu muhakkama, you're paying her below what the customs of society is, what the norms is, what is suitable for her to live on. So look how this hadith, 1,400 years later, is still relevant and applicable in dealing with the problems of society. This qa'id is very important in a Muslim's life, and more importantly in a student knowledge in dealing with these sort of individual issues. Allah musta'an. We're going to quickly move on to some examples, inshaAllah ta'ala. Some of them we've already mentioned anyway. So let's go to, for example, al-qabd fi al-buyu'. Al-qabd is possession. Somebody, you sold something to somebody. That item needs to be taken possession of. Say I bought a phone from you, and I said, or the seller says, I'm going to get it delivered to you. Now, that delivery will vary depending on local customs. Before it was, physical, hand protection, it's physically taking it over with your hand. I don't know whether you have this today, but for example, Amazon, for example, will drop in the UK. What they'll do is you have these boxes sometimes nearby certain homes, like a storage box. And then they'll drop it off there and they'll send you a code so you can go and take it out. That's a form of possession, right? So the form of possession will vary depending on places and times and so on. Sometimes, for example, it'll be dropped off to your neighbor, right? Sometimes you're not home, your neighbor's going to take something and he's going to go and give it to you. That's a valid form of possession in some cases, right? So qabd here in the hadith of the Prophet ﷺ as a condition of buying and selling is undefined. And so it's defined by what? The customs and the norms of society. Imam al-Kasani from the Hanafis, he says, are there any Hanafis here, by the way? No? No Hanafis? Tanweer? No Hanafis. He says, rahimahullah, he says, al-qabdu yata'ayyanu bihasabi al-urf. That possession is determined according to al-urf, according to the customs of people. He says, فَإِنْ كَانَ الْعُرْفُ جَارِيًا بِأَنَّ الْبَائِعَ يُسَلِّمُ السِّلْعَ إِلَى نَقَّالٍ فَهُوَ قَبْضٌ. That if the custom of society dictate that the seller hands over goods to a transporter, for example, and that transporter is a separate company, and any faults, for example, they يتحملون, it's not upon the seller anymore, then he says that's the custom, that's the law. That's it. He's handed over possession of this item. And he says, and he continues and he says, وَإِنْ كَانَ الْعُرْفُ بِغَيْرِ ذَلِكَ فَهُوَ الْمُعْتَبَرُ. That if the norms of society is other than that, whatever, form of possession or taking possession means in today's day and age, then that is also valid. Showing that the concept of taking possession in fiqh varies according to place, time, and societies and so on. The next issue that I want to quickly mention is al-ujra, the wage that you take. Wages, say for example, and this is usually what is referred to as al-ujra al-mutlaqa. So for example, an individual, he started to do work for you and you did not agree on a price with him. For example, a taxi, for example, right? So you jump on a taxi and you didn't have, you're rushing somewhere, you didn't agree upon how much to take you to a certain place. What does he have a right to?
What is commonly paid?
What is commonly paid? The customs of society. Ibn Abidin says in his Radd al-Muhtar, يرجع في الأجرة إلى ما جرت به العادة إذا لم يشترط شيء. That you go back to the norm with one condition, which is if they didn't agree upon something. No condition was set. Take me from there to there for this much. Then whatever is the customs of society is what you give them. You have examples of that from Kitab al-Jinayat. Examples of that is, for example, al-hirz fi al-sariqa. Al-hirz. Al-hirz is what we refer to as a security measure for theft. And so the Prophet ﷺ told us in the hadith that from the reasons why you'd get the punishment of having stolen is if you stole it from hirz mithli, from things that, from something that is secured in some sort of a place. So a secure storage place. If something is lying around, for example, something that was, if you stole, right, your hand be chopped off, it meets the nisab, it's just lying around somewhere, and somebody picked it up. It could have been luqata, right? He could have just thought, I'm gonna pick it up and maybe find the individual that lost it. Wala la. So I'm gonna go and seek or I'm gonna hand it over for the individual. Just because you found something that does not belong to him with somebody does not mean that they stole it. So what is the condition that the Sharia places? Is the condition known as hirz, which is this individual must have broken into a security storage. That is considered theft. If something is lying around, this iPad, for example, somebody picks it up, it's not considered theft. It's just lying somewhere. Does that make sense? Lying somewhere is not the same as stealing. Pick it up could have multiple reasons as to why this individual took possession of it. And so, what is then a security storage? What is a reasonable and acceptable way of storing things? The fuqaha, they say, for example, in Nawawi rahmatullahi majmu', he says, يُعْتَبَرُ الْعُرْفُ فِي تَعْيِينِ مَا يُعَدُّ حِرْزًا وَمَا لَا يُعَدُّ. Anything that we consider storage, you go back to what society thinks is a suitable form of storage. So for example, gold and things like that. For example, spouses that have gold and necklaces and bracelets, stuff like that. Is it left on, kitchen table? No, it's not. It's secured somewhere, right? If it's secured somewhere and somebody comes and breaks into that security vault, then that is considered stealing, okay? But if she took it off and she was left on the table and somebody picked it up, that could have been for multiple reasons. لا يقام عليه الحد. He's not punished for that Islamically.
Unless it is proven that it is.
No, he's not proven, not entirely. It might be ta'zir and other such things. It might be other things that can happen. It might be, for example, the ruler might fine him, for example.
For example, somebody like put his jewelry on the dressing table, for example.
Yeah.
One of the lady, and the maid comes and then she takes it and goes away, and there are cameras, CCTV cameras, whatever it is.
But it's not considered theft. That's what I'm trying to say. Islam does not define stealing like that. It defines that is wrong. And it might be, other things that can happen, ta'zir, other things. The had does not be applied, no. So the hadith literally states hirz, which is you breaking into something. And here there's nothing, it was left lying around. And by the way, even in that scenario, think about it. Who caused it as well from some aspect, some capacity, the person left gold lying around. Why did she do that? It was partially on her to protect her valuables, right? She didn't do it. Why should all the blame be upon the needy person that, سَوَّلَتْ لَهُ نَفْسُهُ بِالْمُنْكَرِ? He's al-nafs al-amara made him, just take something out of maybe poverty or other such thing. So theft is not defined like that Islamically. You have to break into something. Hirz, yes, is one of the conditions of as-sariqa. So the fuqaha, Imam al-Nawawi rahimahullah says here, يُعْتَبَرُ الْعُرْفُ فِي تَعْيِينِ مَا يُعَدُّ حِرْزًا وَمَا لَا يُعَدُّ. That you need to have a security storage, and that security storage is defined by way of the customs and the norms of society. Where you store your phone at night and your laptop and your gadgets and whatever else, and your cameras, mashallah, it's not the same as where you would store gold and things like that, or where you would store other things, right? Money, for example, is money stored where today? Banks, right? If you leave behind, thousands of dinars in your house, and somebody comes in and takes it, that is not a customer. The first thing a judge will say is, what was that doing there to begin with? If somebody had, let's say, 50,000 dinar Kuwaiti lying around on his table, on his house, that is not a suitable storage for money. That should have been in a bank. So that is...
What about hacking?
Fraudulent behavior, exactly. That's a very good example where somebody, gets inside somebody else's bank account, things like that. That is his mithla. He's broken into something, even if it's through, a sort of an electronic measure or whatever it is. But still, that money was stored somewhere, and this person broke in. So yes, you can consider that a modern application of hirz. But the point is, hirz is defined by customs. And so he concludes by saying, فَمَا كَانَ يُعْتَبَرُ فِي الْمُجْتَمَعِ عَنْدَهُ حِرْزٌ ثَبَتَ بِهِ الْحَدُّ. That whatever society considers a suitable location, storage, or a secure storage for this wealth, then that is where the legal application, the had, The punishment of sariqah is applied, the punishment, yeah. We spoke about an-nafaqa, which is the wife's financial maintenance. We're not going to go back to that again. And other such things. Shatibi rahimahullah ta'ala says in his muwafaqat, al-urfu mu'tabarun fi an-nafaqati wa sa'ir ma lam yuhaddidhu ash-shara'. That customs are considered the source of what? The law, what is defined by all of these financial maintenance laws and all matters that were not explicitly defined by the Sharia. The last thing that I want to quickly go through, inshallah ta'ala, before I conclude this principle is that there are conditions for urf to be acted upon. And so not all urf is acceptable, and that is partially what he's hinting at here. And so right here, the conditions for customs to be legally binding. Conditions for urf to be mulzam, for it to be mandatory that you go back to. Because right now, you're going to have a problem. There's two people, two married couple, they've got an issue. One of them is going to be, the urf is going to be imposed upon them, right? It's going to be forced upon them. You have to pay this much because it's urf. So what is the conditions for the urf to be mulzam? What are the conditions for the urf to be mulzam? Here the author mentions one of them, which is that it must not contradict the Quran and the Sunnah. We spoke about why that is. Because the urf, it comes third in line. You've got what is defined by the Quran and the Sunnah, that's number one. What is defined by the Arabic language is number two. Al-haqa'iq al-shar'iyyah, al-haqa'iq al-lughawiyya, and then comes al-haqa'iq al-urfiyyah. So what is defined by the urf comes third. The next issue is that, and we spoke about this slightly yesterday.
After the lughawiyya.
Lughawiyya, yes. It comes after
So
lughawiyya.
we see first of all Quran and Sunnah.
And you
if
see,
it goes against Quran and Sunnah,
yeah.
or if it goes against the language.
Yeah. So if something is defined by the Arabic language.
For example.
So for example, usage of certain terms like night or day. Right? Language of night or day or other such terms. Like sometimes what it is that some people might, like for example, Maghrib, we culturally might still consider it what? Daytime. You might say, oh, it gets darker after Isha's night. But Islamically, the night enters with what? With Maghrib. And so you have to maintain the boundaries of the Arabic language as well. Does that make sense? The boundaries that were set by the Arabic language. That's just a quick example, but you find some real examples that are applicable in fiqh. That's what I was trying to say earlier, that I just want to kind of avoid it for now. The next issue is, when we spoke about yesterday, al-urf al-muttarid or al-ghalib, which is that this urf has to be widespread and accepted practice. Now, you can't come out of nowhere and say, this is urf. And then I have to say, for example, the judge has to say, well, who else agrees with this? I've never heard of it. You know, or anybody else, or the two people that argue is like, you know, where does urf come from? You know, something that you do individually or your family does or whatever it is, that's not urf.
Should be
right?
common.
It should be common. Yes, common, widespread, it's accepted societally. That is one of the conditions of urf. The next is that it must be consistent. Right? It must be consistent and not very random. And the reason why consistency here does not apply to everybody doing it. Sometimes, like I said, there's tabaqat in society, the levels in society. There has to be some level of saying that this, you know, people who, generally speaking, مثلا on this wage gap or this amount of wealth, this is what they do, for example. All of that is reasonable. But if this urf is not consistent, meaning it jumps around so much, with the people of a similar sort of circumstance, they have 5 different urfs. There's nothing that we can apply. So you have to go back to another measurement of determining what is right or wrong in that circumstance. Does that make sense? The last condition is it must exist at the time of the whatever you're dealing with, the contract, the transaction, whatever it is. So it must exist at the time of contract. So what I mean by that is, for example, urf societies, they change. A good example is, and this is a very good one, let's say, for example, if somebody had bought something that was heavy and he needed to get it delivered to his house. Let's say the urf in 1 year was like this. In Kuwait, the norm is that the companies don't deliver this. If you want to get it delivered, you have to pay for it. Right? If you bought a cupboard or wardrobe or whatever it is, these heavy things. Then you took this individual, this company to the mahkamah. Yeah? And then in the space of that year that you're waiting for the you know, who's right or wrong or suing this company,
The custom changed.
the urf changed. And it did become norm because of, I don't know, marketing and whatever else, the companies wanted to get more people to buy this stuff, and so they started to give out bargains like free deliveries. The Qadi is looking at, or is going to look at what? The time of when this transaction occurred. What was the prevalent norm of society then? And so we have to consider that. نووي رحمه الله تعالى says in المجموع ويجب أن يكون العرف قائما في وقت الحكم ومستمرا فإن تغير العرف تغير الحكم معه. So it has to exist of them and it has to continue. And if that changes, then the urf changes with it, but it doesn't change what happened in the past. Okay. And the last thing that I want to conclude this principle with is that as we think about the beauty of this qa'idah as well, and all of its applications, you see it's a very reasonable principle as well. It validates things, invalidates things, and you need like a deeper access to apply it. From the things that the fuqaha of Islam that they say is that a mufti is not somebody who he sits in a maktab all day, doesn't mix with society, because obviously how are you supposed to apply this principle if you don't know anything about society? This is a valid question. It's a problem. If you do not know anything about, I don't know about the customs of people, I don't know what goes on in society, how am I supposed to apply these principles reasonably? And so this principle also gives us an insight into who the scholar that you should be referring to actually is. If you go back to somebody and he's, actually I don't know about this circumstance, I don't know what society does, I don't know about your or this particular custom, maybe don't ask him. Maybe don't ask him, because is he suitable to answer a question when the Sharia bases this hukum on urf and is completely unaware of what urf is? And this is all takes us back to a very important concept, which is that the mujtahid and they have to be mulimun bi'araf nas, and they have to have awareness of the customary practices of society. And this is why the basics is that unless the people involved fully agree on what the custom is, but he has to be amongst them. So you go back to a scholar in your relevant society. You don't dish out rulings to somebody that's halfway across the world. You have to try and seek the relevant ruling and the dispute in wherever you live. And with that, we'll stop this qa'idah. We'll move on to the next one. This is a very important qa'idah. We didn't give it right, but hopefully we understood something about the importance of al-'aadatu muhakkamah. Na'am Mubin. You lifted your hand, I think. Oh, you didn't. Sorry for that. The next principle. Now.
أحسن الله إليكم قال رحمه الله معاجل المحظور قبل آنه قد باء بالخسران مع حرمانه.
This is a very important principle. So it's line number 29. This principle is very prevalent in the books of fiqh. It doesn't have that many applications, but it's really beautiful once you see the benefit of it, inshaAllah ta'ala. The principle is known as man ista'jala shay'an, and some of them define it as man ta'ajjala shay'a. Man ta'ajjala shay'a qabla awanihi uqiba bihirmanih. Principle basically says, or this law, or this maxim says, whoever hastens something before its appointed time. Whoever hastens, rushes to do something. He rushes to go and do something before the time of that thing came about. What happens to him? عُوقِبَ بِحِرْمَانِهِ. He is punished by being deprived of that thing. He's punished with the opposite of what he had wanted. He wanted that thing. The Sharia says, no, you can't have that thing anymore. Is that clear to me? مَنِ اسْتَعْجَلَ شَيْءَ قَبْلَ أَوَانِهِ عُوقِبَ بِحِرْمَانِهِ. You rush to do something, you're prevented from it. Now, we're going to get to examples, inshallah, don't worry. So the poet says, مُعَاجِلُ الْمَحْذُورِ قَبْلَ آنِهِ قَدْ بَاءَ بِالْخُسْرَانِ مَعْ حِرْمَانِهِ. مُعَاجِلُ الْمَحْذُورِ, the one who rushes to do what is haram. Al-mahdhur here means al-muharram, al-hadhru, al-haramu. Okay? قَبْلَ آنِهِ, before its time. قَدْ بَاءَ بِالْخُسْرَانِ, he comes back with a loss, meaning a sin. مَعْ حِرْمَانِهِ, along with being deprived of that. He'll be prevented from that thing. This qa'idah is a very important qa'idah. This qaida basically just states that if a person seeks to obtain something, a benefit or something, in a manner that's unlawfully, prematurely, meaning that had he waited, there would have come a time where that thing would have been halal for him. But he rushes to do something to try and get something. Now, because of that rush, he ends up doing a haram in the process. Then as a result of that, the flip side, he is prevented from that thing as a form of punishment. Why is this principle so important? Why is it legislated? This principle serves as a deterrent, right? It serves as a deterrent. It prevents people from doing something, rushing to get something, because if this was allowed, then people would jump at the opportunity thinking, do something that's haram to try and get it. But now that they know that if they were to do that haram, they're not going to get it, it prevents them from doing that haram. Does that make sense? So it's a prevention mechanism from worldly harm upon certain individuals. And there's a wide-ranging applications to this. The adillah of this are so many from the Quran and the Sunnah as well. So let me go to, the hadith of لا يرث القاتل شيئا. Comes in Sunnah Abi Dawud. The Prophet ﷺ said that the killer does not inherit. Somebody has a mum, a grandmother, or a mother, whatever it is, that is extremely wealthy. They've said to him, we're not going to give you money. He thinks by killing them, he's going to inherit all of their millions. The Prophet ﷺ said what? You don't get a penny. لا يرث القاتل شيئا. You don't get a penny. And so this is a direct example of how this individual rushed. It would have been, had he waited till they passed away, it would have been halal for him. He would have got that money, right? But now that he rushed towards it and did something haram in the process, which is murdering them, he was prevented from that money. Okay, deprived of that money. عُوقِبَ بِحِرْمَانِهِ. He was prevented from that. So the principle, is it clear? Yes. This principle is applied to a range of things. Jot down a number of them. We'll probably mention like a few examples, inshallah ta'ala, quite quickly. From them is killing so that you can inherit, which we just mentioned right now. The fuqaha mentioned, Ibn Qudama says in his Bughni, وَإِن قَتَلَ الْوَارِثُ مَوْرِثَهُ فَلَا مِيرَاثَ لَهُ لِأَنَّهُ تَعَجَّلَ شَيْئًا قَبْلَ أَوَانِهِ فَعُوقِبَ بِحِرْمَانِهِ. That if heir, right, the inheritor kills his benefactor, he does not inherit because he hastens something before its time, and so he was punished with its prevention. Okay? Akhi, if this qa'id didn't exist, how many people would kill, their parents and all? It was very important qa'id. من استعجل شيء قبل أوانه. Similarly, even in wasiyyah. The wasiyyah, there's no direct hadith that links it to it. With regards to the irth, the mirath, there is a direct hadith. But the wasiyyah, there's no direct hadith. Some of the scholars of Islam, they say that the irth the inheritance that was mentioned in the hadith is generic. And so you apply it to the wasiyyah as well. But others from the fuqaha of Islam, they simply say it's this qa'idah that allows for this. So Kasani, for example, he says, "Man qatala al-musi la yastahiqqu shay'an min al-wasiyyah." That whoever kills the individual that wrote the wasiyyah, the willer, right? Then he does not deserve anything of that will. He doesn't get anything of that will. So since he was a beneficiary of that will, but he decides to kill the musi, which is the individual that wrote the will, to try and speed up the benefit, try and get it as soon as possible, he's denied the will as a gift. An example of that is the fuqaha mention is man ba'a ma lam yaqbidhu fabay'uhu batil. Selling before you take possession of something. So I bought something, okay? It's on the way from China. Listen, I was in Kuwait. It's not reached here yet. And I decide to go over to people, do you want to buy this from me? And I start to take money from them and say it's, thing. That transaction is batil. What else does it mean? There's a discussion with regards to that, but the scholars of Islam say that sale is invalid. You have the scenario of what is known as al-ihtikar, which is when an individual hoards essential. So for example, right now, if you realize that the price of, I don't know, shampoo is going up, so I go and buy all the shampoo in the market so that I can raise the price of it. Now, this essential goods, if my intention is to take control of it and raise the price of it, because I've started to see that the price of it is going up, the government has the right to do what? Has a right to seize all of the goods that I bought with that sort of intention, and then go back and sell them at a fair price. Now here in this scenario, that fair price will mean that you'll miss out even on the price increase. And that was because you rushed to get something before you could do it. You thought by taking possession of it, hoarding it, filling up a whole warehouse with it, that you'll get more money. Now you've lost money. And so Ibn Abidin says in Rad al-Muhtar, من احتكر سلعة لزيادة ثمنها أجبر على بيعها بالسعر المعتاد. The individual who goes and hoards a property, an item, goes and buys it in bulk, so that he can, take part in the raising of its price and so on. Now what happens? He's forced to sell it at an ordinary price. Even though maybe that price of the thing was already going up because it was already reducing, right? Circulation of it was going down. The price of it was already going up. But now he's punished with the opposite of that. This next one is a very interesting one from Ahwal al-Shakhsiyyah. It comes regarding a very interesting mas'ala actually, which occurred in the lifetime of Uthman bin Affan radiallahu anh, to one of the Ashara as well, which is Abdurrahman bin Auf. And there's a lot of discussion regarding the athar. And it's known as the man who divorces his wife to deprive her of inheritance. So we say he's terminally ill and he's going to die, right? And his wife, for example, she's bothered him throughout his life, for example, and at last moment now, just as on his deathbed, he thinks, I want to divorce her and prevent her from any inheritance. So he goes and tries to divorce her then. Does she inherit or does she not? Now that bad intention, it impacts it. Because he rushes, right, to do that. So he's prevented from that. So the Ibn al-Qayyim rahmatullah says,
for giving her talaq?
Yes, the talaq. So he's إذا طلق المريض امرأته في مرض الموت. If there's the one that's terminally ill, divorces his wife in that, those last moments of sickness of his life, فإنها ترث. The principle of the Sharia is that she will inherit, even if she's divorced. Right? Because يعاقب بعكس ما نوى. He is punished with the opposite of what he wanted. لأنه تعجل حرمانها فحرم المقصود. Because he rushed to try and prevent her, and so he was prevented from what he had intended. There are other such examples, and there are many. One last example that I mentioned from Kitab al-Jinayat. Kitab al-Jinayat is a bribery in a court. So say somebody, he realizes that the hukum is going against him. They're preventing their case for, a court case. And he goes and he decides to bribe the judge. Slip him some money under the table. So maybe not even that particular judge, but the court itself, the whole system of qada, they discover that this judge was bribed. What happens?
The verdict is reversed.
The one that bribed, he automatically is punished with being or losing that case. And so here, Imam Malik rahimahullah ta'ala would say, "Man rasha qadiyan liyahkuma lahu bighayri haqq." Whoever bribes a judge so that he could get a ruling passed without due right. The purpose of qada was idla' al-bayyinat, was to present their evidences. You can't just have it your way. You can't just throw money around. He says here, فَإِنَّ حُكْمَهُ لَا يُنْفَذْ. That he's لَا يُنْفَذْ there. So it's not given what the ruling is not valid in his favor. So it's invalidated from his perspective. I want to conclude this qa'idah as well with a number of points. Number one, we see in this qa'idah that obviously doing haram, you get that sin. That was not really the purpose of it, because that is a given. قَدْ بَاءَ بِالْخُسْرَانِ. So the sin was a given. The fact that you are sinful for the haram that you do was always known. But the one that the Sharia adds on is مَعْ حِرْمَانِهِ, that you're also deprived of the end goal or the ultimate goal that you had sought. We've seen how this qa'idah applies to different chapters of fiqh, and that the purpose of this is to prevent any form of manipulation that leads to any form of ضياع الحقوق, for rights to be taken away and so on. Now sometimes, subhanAllah, like even for example, Abdurrahman Auf, you still feel sorry for, because generally speaking, maybe somebody had a valid reason to do that, to do certain things. But the people of knowledge say that if you were to open the doors to this, it would lead to a lot of problems. Like how many people would do certain things just because maybe for one person it would have been okay. So even in the context of the qadi, for example, somebody may have generally he might have been right. But because of his approach, if that was allowed, if that became normal practice, لَضَاعَ الْحُقُوق. Like all these rights of people would disappear, and every person would bribe judges to get their way, and whoever has the most money would win every court case. It would be settled in his favor. We'll move on to the next principle, inshallah ta'ala. Do we have time still?
Yes. Oh, yes.
Alhamdulillah. The next qaida now.
وإن أتى التحريم في نفس العمل أو شرطه فذو فساد وخلل.
So this principle is to do with a qaida that is known as النهي يقتضي الفساد. النهي يقتضي الفساد. النهي is a prohibition. We're going to talk about the difference between a prohibition and a negation shortly anyway, the next principle. So النهي is whenever you say, do not do this. So it's a command with absence, to not to do something. And nafi is when you say, this did not happen. So you're negating the occurrence of something. And there's a big difference between the two. Nahi is you're commanding somebody not to do something. Nafi, your khabar, you're saying this did not happen. Does that make sense? So they differ essentially. This principle is to do with prohibitions. The question is, do prohibitions necessitate invalidity? Meaning that anytime you see that the Sharia prohibits something, does that mean that that thing that is prohibited is automatically invalid or not? The fuqaha of Islam have a tafsil here. They've got a principle that helps us clarify or helps us understand when something is invalid and when it's not. Before we get there, النهي يقتضي something first. What is that?
النهي يقتضي الفساد.
Before we get to fasad, the default position of nahi is at-tahrim. The first principle we need to know is an-nahi yaqtadi at-tahrim. That any prohibition, the default position is that it's haram. Every command, the default position is what? It's wajib. Every command. The default position is wajib. When there's an amr mutlaq, it shows it's obligatory. When there is a generic prohibition, it shows that it is prohibited. That is the default position. But the question is, okay, let's say for the sake of argument, that thing is haram. But just because it's haram, does that mean it's invalid as well? Just because it's haram, does that mean it's invalid as well? The author here says no. There's a principle that governs this, and the answer is no. It's invalid in two scenarios, and it's valid in two scenarios.
Invalid means what?
Invalid means that thing that you've done, you've still got the sin, but is, for example, that prayer accepted? Is that transaction correct? Okay? Things like that. So validity here means, do you have to redo that salah? Do you have to restart that transaction? The author says no. There's tafsil. There's a slight detail to this, and that's what we're going to cover here. بإذن الله تبارك وتعالى. So he says, rahimahullah, وَإِنْ أَتَى التَّحْرِيمُ فِي نَفْسِ الْعَمَلِ. That if the prohibition, which was haram, what we said? The nahi is, the first principle is every nahi dictates, or the default position of every prohibition is that it's haram. It shows that this thing is a sin, and by doing it, you incur a sin, the punishment of Allah, you are liable to the punishment of Allah, and also that there is no reward for such an action. It's a sinful action. So he says here, number one, that if any tahreem comes about in that connects to a specific action, Yeah, to fi nafs al-amal, meaning to the act itself. And that is the first scenario. So that this haram, it connects to the action itself, or أو شرطه, or its condition, a prerequisite that was specific to it. Not a condition that is generic as we'll see, but a specific condition that connected to that haram. Then he says, فَذُو فَسَادٍ وَخَلَلٍ. Then that action that is muharram is also attributed with invalidity and flaw. Invalidity and flaw. What is this qa'idah? This qa'idah basically says that not every prohibited act is automatically invalid. There are things that are haram, but they're not void. You know, sometimes it can be void and invalid, sometimes it is not. And so you need to determine when it becomes invalid and when it does not become invalid. And so here, to understand this inshallah ta'ala better, we need to understand the concept known as the 4 scenarios of this prohibition. Number 1, to examine it, inshallah ta'ala, we're going to see it with examples, but the 4 scenarios are the النهي العائد إلى نفس الشيء, which is the prohibition that goes back to the very essence of that thing. Okay, the very essence of that thing. So this thing's haram, but it's to do with the very essence of that thing, the very objective of it. Literally, the thing cannot come about. The whole purpose of doing this thing was with that intention. And so undoubtedly that has to be haram. We're going to see the example of that. Then we have shart. Shart has 2 scenarios. شرط يختص به وشرط لا يختص به. شرط الذي يختص به is the condition that is specific to the action. In this scenario as well, it becomes haram. It becomes haram and it becomes fasid. It becomes invalid. If it's not connected to, if it's a condition that does not connect directly to the action, it is not invalid. And the last scenario is when it's that prohibition is connected to an external factor to the act, then that definitely does not invalidate it. So let's try and understand this a little bit more. Let's try and understand this a little bit more by way of some examples.
You mentioned 4 scenarios, right?
What did you say?
You mentioned 4 scenarios.
Yeah.
Very good.
So the first scenario is the prohibition that connects to the act itself.
That's the first.
Yeah.
Second is shart.
The second scenario is the condition, but that condition is a condition that is specific for the act. The third is a condition, but it's a generic condition.
There are 2 cases.
Yeah. And the fourth is an external factor, amrun khariji. Amrun khariji. Okay? It's got nothing to do with a thing. So the 4 types, so we can quickly see some examples, okay? So the fuqaha, for example, kitab أحكام العيد. They mentioned a book of Salah, kitab al-Salah, in the chapter of al-Eidain. They mentioned, for example, or kitab al-Siyam. Let's take the Siyam one. It might be a bit more obvious. Al-Siyam Yawm al-Eid. Somebody decides to fast on Eid al-Fitr and Eid al-Adha. What happens there? Haram. We agree upon that. Haram was a given. Invalid. Why is it invalid?
Because
There is a clear, it's connected to the 8 days.
connected to the
So Ibn Qudama rahimahullah says, "As-Siyam fi Yawm al-Eid muharram wa batil." Then he goes on to explain why it's batil, why it's invalid, why that fast is invalid. And he says, لأن النهي عائد إلى ذات العبادة. Because this prohibition goes back to the very act of worship itself, which is what?
prohibition.
The prohibition of fasting on this day goes back to the very essence of it. Another example of understanding that al-ibadah, the very essence of it. Maybe that one was not that clear, okay? Whoever marries a woman that is still in an iddah period. The first ruling is obviously what? Haram. You're not allowed to marry a woman that's still in iddah period. So marriage to a woman during iddah period is number 1 haram. But it's also what? It's also batil. Why is it batil?
Condition.
Because this is a prohibited time in which you can.
Okay, so I'm going to quote Imam al-Nawawi rahimahullah ta'ala, and then we'll break down this a little bit more, because this one's a very good example of this. If you don't understand if you don't understand how to apply it best, don't worry about it. You'll see, like as time goes on, you'll be able to learn how to apply it better. But he says, rahimahullah, مَنْ نَكَحْ امْرَأَةً وَهِيَ فِي عِدَّتِهَا فَالْعَقْدُ بَاطِلٌ بِالْإِجْمَاعِ. Whoever marries a woman in her iddah period, then that contract is null and void by consensus. Why? What was the reason for the iddah period? What is the purpose of marriage? Lineage. That she could be bearing a child and you don't know who would the father be. So how can such a nikah be valid if the whole purpose of a marriage is to maintain people's ancestries and lineages, and she could be bearing a child and we don't know who the father may be? That opposes the very essence of nikah in itself, having that marital contract. And so he says here that it's batil. But this butlan goes back to what? The very essence of the act. Okay? The very reason why nikah was legislated. Does that make sense? Is that clear? That example is clear. Okay, let's move on to the next one, inshallah ta'ala. Next one we said is a prohibition that goes back to a specific condition. Nahyun a'idun ila shartin yakhtassu bihi. So here, the fuqaha also say it shows invalidity. The action is invalid. Haram is a given. Invalid happens to. Like what? A good example, I think you'll understand, is the Prophet ﷺ in countless hadith prohibited us from praying in the pens of camels. So you know the places where ma'atin al-ibil, where the camel rests, right? La tusallu fi ma'atin al-ibil. The Prophet ﷺ said, that do not pray in the places where camels rest. Now, are there any other acts of worship that relate to not doing it in where camels are? Can you, when you're fasting, can you go near a camel? Or is it related to it? So this prohibition of, what to do with camels is specific to what? Salah. So what do the fuqaha say? If you go and pray there, what happens? Your salah is invalid. Does that make sense? Your salah is invalid. Imam al-Kasani says here in his Bada'i al-Sanaya from the Hanafis, he says, as-salatu fi ma'atin al-ibili batila. Praying in the places where the camels reside and live and where they go to bed at night is invalid. Because he said, لأن النهي متعلق بشرط العبادة. Because this prohibition goes back to a specific condition of that act of worship, of that prayer. With that, let's look at another one, inshallah ta'ala. If a woman was to pray without hijab, what is the ruling of that? Why? Isn't hijab wajib upon her throughout the day?
Not throughout the day, but
when she's around men. So why is it specific here? What was
the condition of the prayer?
So a hadith that show that women covering themselves properly, and even men wearing certain clothing covering them properly, is, or the aura of the man and the women, the hadith that show that this is a specific condition for salah as well. Okay? So if she was not to wear her hijab, her salah would be batil too. It would be invalid. Ibn Abdul Barr rahimahullah ta'ala says, إِذَا صَلَّتِ الْمَرْأَةُ بِغَيْرِ خِمَارٍ فَصَلَاتُهَا بَاطِلَةٌ. If she was to pray without a khimar hijab, then her prayer would be invalid. Without a headscarf, her prayer would be invalid. Does that make sense? Here, one of the things you need to know to understand this topic a little bit better is you need to be aware of the hadith and the evidences of these rulings to be able to apply them really well. But this principle is really beautiful and it helps understand this concept really well. It's just we need to also learn the evidences of these chapters to be able to apply them in the best manner possible. The next one is prohibitions that go back to a condition, from the conditions of maybe an act of worship or something, but it's not unique to, not specific. A good one that I would say to help us understand is from the conditions of salah, like for example for men, is to cover their awrah, right? You have to wear clothing. Are you allowed to wear harir? Are you allowed to wear silk? It's haram to wear silk. But wearing, the prohibition of wearing silk, does it go back to salah or is it generic prohibition? Generic prohibition. If a person was to wear a thobe that was made of silk, would his salah be valid or invalid? Valid. Valid. And that is where, can you see how daqiq this principle is? Does that make sense? Can you see how specific it is? Shaykh al-Islam Taymiyyah rahimahullah says, "As-salatu fi thawb al-hariri sahiha, lakin lubsuhu ithmun, wa labisuhu athim."
He'll be sinful.
He'll be sinful, but the act of worship is what? There's no hadith that says, do not make sure you pray without silk. Does that make sense? It's not specific to silk, it's generic to. Do you see how specific this principle is? That's how you have to almost look at it. The last thing that I'm going to quickly mention, inshallah ta'ala, is this one. Let me look for a difficult one to kind of get you off your... the prohibition of the external factor. Okay? النهي العائد إلى أمر خارج عنه. So here, the individual is sinful if he was to do so, but the act of worship is what? Oh, forget about the act of worship. Let's do an example of transaction. Yes, external factor. Amrun khariji.
How do you complete it?
So let's do it with mu'amalat this time. Now let's do a bay'. Let's do buying and selling. An individual went to a shop and bought something after the second adhan of Yawm al-Jum'ah. What is the ruling of that buying and selling? And it's also? Invalid. Who says valid? Who says invalid?
Invalid.
The deal is invalid.
Is the deal invalid? The deal is valid. Why is it valid?
Because the deal fulfilled the conditions of the deal.
You fulfilled the conditions of the deal, that's true, which is the conditions of buying and selling, were literally the 4 pillars of buying and selling, has nothing to do with the time that you sell it in. The time that you're selling in is not conditioned. So this is something that's completely external, okay? There's nothing that comes regarding the time that you are allowed to sell things and not sell things. The ayah, وَذَرُوا الْبَيْعَ, how do we understand that? Imam al-Shafi'i rahimahullah ta'ala says in his الْبَيْعُ بَعْدَ نِدَاءِ الْجُمْعَةِ صَحِيحٌ. Buying and selling after the second adhan of Jum'ah is valid. لكن البائع آثم. The seller is sinful. Okay? So separate here between the concept of sin and the concept of the validity of that. I'm going to quite quickly go through the ayah quickly there, and we'll move on to the next principle, inshallah ta'ala. نعم. إذا نودي للصلاة من يوم الجمعة فذروا البيع. Ayah of Surah Al-Jum'ah. So there's the prohibition of engaging in business transactions after the second call to Jumu'ah. Now here,
It's not Amr from Allah subhanahu wa ta'ala.
it's an amr from Allah. But this command does not relate to Jumu'ah itself or the transaction itself. It relates to Jumu'ah, which is why you're sinful for that. But the transaction itself, you see the difference. So the Jumu'ah, leave it off. And that's it's to do with Salat al-Jumu'ah. As for the transaction itself, it's not a condition for it. So when you're looking at the validity of the transaction, you're looking at it from the transaction only. Okay? So from the conditions of transactions is not buying and selling in a certain time frame.
You mentioned the seller is the sin is on the seller, not on the buyer.
No, they're both. But in that context, when Imam Shafi says al-Bai', he actually means both. Because al-Bai' يطلق على البائع والمشتري. They mean both actually. They mean both. Ibn Qudama rahimahullah, let me just read this quickly. Ibn Qudama explains it and he says, النهي لا يعود إلى ذات البيع. وذر البيع, leave off selling. He says it does not go to the essence of buying and selling. Nothing to do with that. He says بل إلى وقت وقوعه. It's a discussion regarding the time of, when this sale occurs. And he says وَلِذَلِكَ, for this reason لا يقتضي الفساد. It does not show fasad al-manhi an, the invalidity of that which was prohibited. It does not render it invalid. So one of the things that you see here is the essence of the transaction is what is being discussed. The essence of the transaction is what? The buyer, the seller, the goods, right? And the rulings that are attached to all of that. The goods and also the money that you're going to receive in exchange for that. These four aspects, time has nothing to do with any of them. It just so happens that the timing of this transaction occurs at a time where we should be engaged in the worship of Allah. So the fuqaha said the transaction is still valid. What happens as a result of this is the sin of having disobeyed the command of Allah. Okay? And that's the only thing that happens. And so, again, look at it from the essence of, or if you want to jot down, why it's an external factor, right? There is no defect in the contractual elements, which were what? The offer from the seller, the acceptance of the buyer, the price that you give in exchange, and the object of sale, al-muthman. None of these essence or the elements of buying and selling in Islam were touched by the timing of this thing. So the validity stands. It's a valid transaction. But what disappears or what goes is the sin or the lack of it, depending on when you sell. Is that clear or? Khalas, inshallah. Should we move on to the next principle? How much time do we have left?
Enough time we can take.
We still got time. Alhamdulillah. The next principle, this by the way is a very important principle before we get a thing. Yeah. 10 minutes, yeah? We'll finish the next one, inshallah. This principle that we just did right now is very important. But like I said, just need more examples to practice on so that you get the hang of it. But it's pretty straightforward, inshallah, Joe. Don't overthink it. The next principle now.
ومتلف مؤذيه ليس يضمن بعد الدفاع بالتي هي أحسن.
So this is the principle of al-Dhaman, or another principle that relates to Dhaman. Dhaman is one of those issues that creep up all the time. Some of the scholars of Islam actually have some really good books on Dhaman. It's really very important to understand it. Dhaman, like I said earlier, is liability, compensation, and things like that. Here the author looks at it from a specific angle, which is the liability in perspective of the aggressor. So عدم الضمان في دفع الصائل. عدم الضمان في دفع الصائل. So he says ومتلف مؤذيه ليس يضمن بعد الدفاع بالتي هي أحسن. ومتلف مؤذيه, the one who destroys something, yeah? Mutlif, itlaf, you destroy something in the process of what? Mu'dhihi, whilst that thing was bringing about and incurring harm onto you. Laysa yadmanu. Laysa yadmanu. He does not need to pay compensation for that thing that he destroyed, or he's not held liable for that thing. Then he explains one of the conditions of it, which is ba'da ad-difa'i billati hi ahsanu, after he tried to repel it in a manner that was appropriate, and suitable. Maybe like push it away before you do something more severe. Something more severe happens. So you don't just escalate to the most the most harmful thing that you have in your arsenal. You try to do the least possible harm first. Doesn't work, you go up in stages of that. What is this principle? Like I said, it's that there's no liability on the individual that repels an aggressor. There's no liability on the individual that... عدم الضمان في دفع الصائل. There's no liability on the individual that repels an aggressor. This principle is regarding self-defense and the protection of property. So what you have is, you've got, say for example, a person, he's under attack by somebody else. It's causing him harm. And in this process of this person attacking you, say for example, somebody punches you, and to try and push it back, you dropped on the floor. His phone drops out of his pocket and it smashes on the floor. Okay? That process of you pushing it back led to the destruction of his phone. Does that make sense?
Yes.
That damage on his personal property was caused by what? By your push. But your push stemmed from what?
Because he
Self-defense. Okay? So what happens in this case? You say to the individual that caused the damage, you say you're not liable. Why?
Because you started it.
You started it. You were repelling an aggression. You were repelling an aggression. The second half of this principle states that self-defense has to follow for you to not be liable. Right? You'll be liable if you don't follow this condition. But it has to follow a mechanism, which is that you gradually approach this with something more severe. So for example, you push him. That doesn't work. You do something more severe. That doesn't work. You do something more severe. Somebody comes and fights you, for example. Pushes you, punches you. You pull out a gun and you shoot his head. You go to court, they say, we're going to chop your neck off. And you say, I heard in the dentist that, لا يضمن دفع الصائل. He punched me. This doesn't work. So this condition is very important, the second line. بعد الدفاع بالتي هي أحسن. You have to follow a gradual approach. Do the least possible harm. You can't jump to something which is very severe and expect a normal outcome. Okay? So you start with the least harmful means and then you escalate. You keep going up if the aggression continues when necessary. And that's the meaning of this qa'idah. If you want to write the complete version of the qa'idah, including this condition, then they say من أتلف شيئا دفعا لمضرته فلا ضمان عليه. من أتلف شيئا دفعا لمضرته فلا ضمان عليه. That the individual that destroyed something in the process of self-defense because of the harm that's going to occur on him, no dhaman. He is not liable. He does not need to compensate. بعد الدفاع بالتي هي أحسن. After his attempt to push him away and to keep him away in a manner that was reasonable and responsible. Ayat and a hadith that speaks about this qa'idah are many. فَمَنِ اعْتَدَى عَلَيْكُمْ فَاعْتَدُوا عَلَيْهِ بِمِثْلِ مَا اعْتَدَى عَلَيْكُمْ. Somebody pushes you, no gun, yeah? No, you can't do that. That's an unnecessary escalation. لا يحب الله الجهر بالسوء من القول إلا من ظلم. Again, somebody said something about you. You can say something bad again or verbal abuse. But the ayah does not allow mother for you to go beyond that scope. There've got to be boundaries, right? And so there are certain things that happen.
Examples.
The hadith, there's a famous hadith that comes in Sahih Muslim regarding the fitan that occurs, where a man comes to the Prophet ﷺ and he asked, Ya Rasulullah, أرأيت إن جاء رجل يريد أن يأخذ مالي. A man comes, wants to take my wealth. Forcefully take possession of my wealth. The Prophet ﷺ said, فَلَا تُعْطِهِ. Don't give it to him, fight him back. Then the man says, فَإِنْ قَاتَلَنِي. What if he starts to fight me? Physically wants to incur harm upon me. Then the Prophet ﷺ says, فَقَاتِلْ. Then you fight back. But again, within that boundaries. Then the man asked and he says, فَإِنْ قَتَلَنِي. What happens if he kills me in the process? Then the Prophet ﷺ says, فَأَنْتَ شَهِيد. And then the man says, فَإِنْ قَتَلْتُهُ. What about if I kill him? And then the Prophet ﷺ says, فَهُوَ فِي النَّارِ. That he is in hellfire. And again, all of this you see, the concept of, the escalation and trying to maintain that gradual approach in how you do so, alongside the very essence of this principle, which is what? That the Muslim has a right to defend themselves and their property, even if it leads to killing the aggressor. This qa'idah is applied in various different chapters in Islamic law, in Sharia, and we're going to see examples of that. I'll try and maybe take out a few, inshaAllah ta'ala. From amongst them is obviously Kitab al-Jihad. You find loads of applications of this, where the individual defends himself, and anything that comes out of that, لا ضمان عليه. There is no liability or compensation upon him. Ibn Qudama rahimahullah says, وَمَنْ صَالَ عَلَيْهِ غَيْرُهُ. Anybody that, an individual comes and he attacks him, فَدَفَعَهُ فَقَتَلَهُ فَلَا شَيْءَ عَلَيْهِ لِأَنَّهُ مَأْذُونٌ فِيهِ بِالشَّرْعِ. That if, you end up killing this individual, there's nothing upon you. Like the hadith moments ago read said. Why? Why do you not pay diya, for example? Because diya is a form of dhaman, right? The blood money is a form of dhaman. Why do you not pay this blood money? He says here, لِأَنَّهُ مَأْذُونٌ بِهِ الشَّرَعِ لِأَنَّهُ مَأْذُونٌ فِيهِ بِالشَّرَعِ. That the Sharia allowed for you to do that, which is, it permitted self-defense for you. The fuqaha of Islam speak about the issue of rape, for example. A woman, somebody wants to do that fahisha to her, and she defends herself in the process, and it leads to the man being killed. No, nothing as well. She's not liable. Why? Because that happened in the process of self-defense. Nawawi rahimahullah ta'ala says, إن دفعت المرأة عن نفسها وقتلت المعتدي فلا قصاص عليها. There is no qisas. There is no retribution or even blood money, any of that. All of this is hadar, as they say in the books of fiqh, right? It's khalas, it's gone, because he was the aggressor. He was the aggressor. Similarly, in the chapters that relate to wealth, for example, somebody comes into your house trying to steal. Ibn Abidin from the Hanafis, he says, وَلَا قِصَاصَ عَلَى مَنْ قَتَلَ سَارِقًا دَخَلَ بَيْتَهُ لِأَنَّهُ يَدْفَعُ الظُّلْمَ عَنْ نَفْسِهِ. There is no qisas, there is no retribution upon the individual that kills a thief, that entered his property, trespassed, broke into his house, and then wanted to steal from him. Why? Because he is يَدْفَعُ الظُّلْمَ عَنْ نَفْسِهِ. He's repelling oppression and aggression from himself. He's repelling injustice from himself. But remember the second half of the principle. If you can stop him from stealing and get him out of the house, that's one thing. Don't just pull out the gun. Similarly, the people of Mali speak about the transgression of animals sometimes that happen, repelling harmful animals. You find an animal that belongs to somebody. A camel, for example, attacks a person. Imam Malik rahimahullah ta'ala would say, إِذَا صَالَتِ الدَّابَّ عَلَى أَحَدٍ فَقَتَلَهَا فَلَا ضَمَانَ عَلَيْهِ. That if in that moment of, like for example, a camel going mad and injuring people, if somebody comes and kills this animal, and for example, it happens in dogs today in this society. Sometimes dogs, behave very aggressively to certain individuals. And somebody comes and he kills the animal. There's nothing upon you. You're not liable for that action. Why? Because it was in self-defense. Similarly, fuqaha speak about destroying harmful objects. There's this very famous example that some of the early generations of Muslims you speak about. Like say, for example, somebody was on a ship. You have to remember what boats and things looked like back then. And then there's like a heavy product, for example, and it's falling on him because of the tides of the waves and so on. And so he pushes it away from himself and he tips it over the boat and it falls into the sea. And you can't recollect it anymore. It's not his fault. He's not liable. لا يتحمل شيء. He's not liable for the destruction of that property. Why? Because it was harmful to him. It was in self-defense. And so, Shāṭibī rahimahullah ta'ala says, إِذَا أَتْلَشَ شَيْئًا لِدَفْعِ الضَّرَرِ عَنْ نَفْسِهِ فَلَا ضَمَانَ عَلَيْهِ. Somebody destroys somebody's property to try and remove some sort of, prevent harm from reaching him, there is no liability upon him. No.
If you're not doing acts like these on self-defense,
Yeah.
but you're trying to protect, you're a witness and you see some kind of aggression towards someone and he's not able to protect himself.
Mm-hmm.
So does this ruling apply to find trying to help him?
Yeah, it applies. And by the way, this is an aspect of the story of Musa alayhi salam that's very important. Musa alayhi salam interjected harm upon other people. He wasn't in harm's way at that moment in time. right? So this is an act of a prophet, and this is an aspect of, see how without understanding this principle, you can almost like misunderstand what had happened in the case of a whole Nabi. And maybe, to tahammalu khata'an. You might think that he did something wrong, when in reality, the Sharia allows for him to do what he did, because he was repelling harm from another person. But in that process, somebody died. And so he was absolutely right. He did nothing wrong. And yes, that happens a lot sometimes, but the general sort of stance of where the scholars speak about when it comes to this issue is that somebody who is not directly in harm's way, that usually he finds more ways of de-escalating the situation. So it's like if two people are fighting, you can come and maybe grab the other person without doing something that leads to more harm. So the person they initially speak about is a person that the harm falls on primarily. With the other one, he has more room to decide how to best approach it. He actually has the framework of being able to think, how do I stop this from happening without any sort of major harm? The last thing that I quickly want to mention is the conditions. And one such condition that he mentions here, rahimahullah ta'ala, is that the response is proportional, which is the second line here, which is بَعْدَ الدِّفَاعِ بِالَّتِي هِيَ أَحْسَنُ. But there are three main principles that the fuqaha mention. Jot them down quite quickly because they're all very important. The first one is that the threat must be real and immediate. That the darar is haqiqi and it's mawjood fil hal. The threat is real and it's immediate, it's there. And so if, for example, you're imagining, if somebody's walking down and you think he's a threat to you and you're imagining problems, then you are liable. If he did nothing in reality, but you think just by him walking down the street like that he's going to harm you, then you're in a mistake. The second thing is, if he's making verbal threats of what he's going to do, but it's not a real threat that's actually going to cause harm, it's not immediate, like it's not physical, it's not taking something, but it's just saying things, then you also do not have the right to react. So the fuqaha mentioned two there, which is real, and it has to be immediate. It has to be there and then.
You can't react verbally.
Which one?
If they attack you verbally, you can't react verbally.
No, attacking verbally, you can react verbally. But if somebody says, I'm going to do this, and you say, you're going to do that, I'm going to kill you as well, and start killing, that's where there's a problem, So the understanding of is you reacting physically when somebody has done something verbally. Exactly. That's where the problem is.
Second.
The response has to be proportional. And that is what he mentioned here in the second line. بَعْدَ الدِّفَاعِ بِالَّتِي هِيَ أَحْسَنُ. It has to be proportional. You're not like escalating things unnecessarily. If you can cause like a minor injury, you're supposed to cause a minor injury. Right? It shouldn't automatically lead to somebody losing his wife or life or the entirety of his wealth or whatever it might be as a result of something that you could have reduced to a certain level of harm. And so the meaning of proportional here is that you do the least harmful thing first. And then you escalate from that as you go through protecting yourself or your property. So for example, if verbal warnings suffice, then physical force is haram. It's not allowed. By threatening him, he'll stop. Yanzajir, then you can't physically harm him. And so on. The examples of this are many.
Good.
And the third, which is really where the mahal al-qa'ida is, that it's the outcome of this, which is if a destruction occurs, if there's an itlaf on his body, physically, or wealth, then there is no dhaman. Why is there no dhaman? Because it was necessary to prevent harm. It was necessary. The third point is that if there was any destruction, either to his body or his wealth, then there is no liability, there's no compensation. Why? Because it was necessary to prevent harm. It was necessary to prevent harm. This qa'idah here, the author rahimahullah speaks about the concept of repelling harm, liability, least possible force, the principle of the Sharia that it allows self-defense for individuals, communities, countries, right? You have, whole countries not being attacked. Self-defense is wajib. Jihad al-dafa was legislated for that. And that excessive force is that which is not allowed. And we'll stop here inshallah ta'ala.